Start. The primary contention which was canvassed on behalf of the appellants and writ petitioners was that insofar as scheduled castes, scheduled tribes, and OBC candidates are concerned, the prescription of a cut-off date for the production of caste certificates is wholly superfluous and of no significance whatsoever. It was submitted that a caste certificate is essentially a recognition of a status already obtained and held by a candidate belonging to the aforementioned three categories. It was short to be contended that the caste certificate was not a document conferring a particular status. Elaborating upon this submission, it was submitted that a candidate belonging to the scheduled caste, scheduled tribes, or for that matter, the OBC category acquires that status by virtue of belonging to a particular caste, category, or group. The certificate, therefore, it was submitted was in essence a recognition or certification of an already existing status. In this view, learned counsels submitted that even if the caste certificate was submitted after the last date prescribed in the advertisement, the same could not be refused. It was further submitted that the prescription of a last date for submission of such a certificate clearly did not prescribe to any rationale, inasmuch as a holder of the said certificate belonged to that particular category even before the date prescribed in the advertisement and even thereafter. It was then submitted that such a prescription being read into the provisions of an advertisement or recruitment notice would not only be irrational and arbitrary but also violative of the constitutional guarantees enshrined in Articles 14, 15, and 16 of the Constitution. Insofar as question number 3 is concerned, the issue itself came to be formulated in a light of the submission advanced by learned counsels that there was no repugnancy between the creamy layer standards stipulated by the state and the union government. It was short to be demonstrated before us that the benchmarks formulated by the union government were lower than those prescribed by the state, and therefore merely because the certificates produced were with reference to appointments to posts under the government of India, the same could not be discarded by the state respondents. The learned Chief Standing Counsel appearing for the state drew our attention to the provisions of the advertisement to contend that all participating candidates had been put to adequate notice that a caste certificate was to be obtained and submitted in a prescribed format. He further contended that the advertisement not just prescribed time limits within which a caste certificate on the prescribed format was to be submitted, but also stipulated the consequences of a certificate not being submitted within the time fixed thereunder. He further sought to highlight the fact that for 1865 vacancies which came to be advertised, the board received as many as 41,000 applications. It was his submission that in the recruitment process, as many as 391, 37, and 503 vacancies stood identified as being reserved for scheduled castes, scheduled tribes, and OBC candidates respectively. Stop.